Greetings, Advocate James Mateja, and thank you so much for affording us this opportunity to have this chat with you. As the resident panelist of the PHSD-SBC, please tell us a bit about the new judgment on the interpretation and application of collective agreements at the PHSD-SBC.
Thank you very much. Thank you very much for the opportunity. Before I talk about the judgment itself, let me just give some bit of background so that there is an understanding from the parties in respect of the jurisdiction of the bargaining council in respect of matters to which the judgment relates to. Section 24 of the Labour Relations Act deals with disputes that might arise in the interpretation and application of collective agreements. As you know, the public service is a highly unionized and highly regulated environment. So the parties to the collective agreement would enter into a collective agreement, and practically there would be instances where there are disputes that arise from those collective agreements that would have been entered into. So the judgment we are referring to is a very important judgment, which was delivered by the Labour Appeal Court, which deals with who can refer disputes to the bargaining council arising out of a collective agreement that would have been entered into by the parties.
When then did the judgment take effect?
All right. The Labour Appeal Court delivered the Sakusu on behalf of CASPA versus Minister of Justice and Correctional Services judgment on the 18th of December 2024. And in terms of the manner in which judgments work, it takes effect from the date on which it was delivered.
What would then be the implications of this judgment?
The implications are that prior to that judgment, there was a judgment which was the Dupree versus, which what we call as the Dupree matter, where the Labour Court had held that individual employees as well as trade unions who were not parties to the collective agreement could not refer disputes in terms of Section 24 to the council. So the implication of that judgment is that the council now would have jurisdiction to deal with disputes that were referred by non-parties to the collective agreement in the form of individual employees, as well as trade unions which are not party to the collective agreement. And in that way, it extends the scope of the work that the council will do, and it will ensure that the council is able to deal and resolve all disputes that are referred by the parties as well as non-parties in the sector.
That'll be all from us today, and thank you very much again for this opportunity.
Thank you.